We cross live to those proceedings.
A convicted person at this stage. So after the conviction, the state had no basis to oppose bail other than that he was convicted. And then it says, and with a convicted person, one cannot turn a blind eye on the fact that a person may evade the trial. However, if the court decides that he should be granted bail, I agree with my colleague that it should not be the same bail. It should be extended, actually. I don't have an objection. It could be 6,000 rands. The court then deals with this issue, and then it notes, regarding the extension of the bail of the accused or not, he has stood his trial so far. A number of bail conditions were imposed by the bail court. I have not been convinced that the accused is a flight risk. So, under the circumstances, this court is prepared to extend the accused bail. Whether to increase the bail or not, a suggestion has been made that it be increased by 1,000 rands from 5,000 to 6,000. Then Your Worship concludes, I don't think that this is going to make any difference. So I will extend this present bail to 5,000 rands. That goes with the bail conditions. In other words, the bail conditions remain. So, prior to conviction, he was out on bail of a relatively modest amount. It was common cause, it was accepted that he is not a flight risk, he will stand his trial. Subsequent to his conviction, this very debate happened. This prosecutor didn't oppose, in fact admitted that he is not a flight risk. Your Worship, in the exercise of your judicious and judicial mind, said you are not convinced that he is a flight risk. You were not even convinced that it was necessary to increase the amount subsequent to the conviction. Nothing has changed in relation to that consideration about whether or not there is a risk that he will serve out the rest of his sentence. Because the facts that we knew then, the only fact that has changed now is that he has been sentenced. But none of these other objective facts have changed. And so Your Lordship was judicious enough, even after conviction, to say that this person is not a flight risk. There is no reason to believe he won't stand his trial. Mr. Cekeshe is still not a flight risk. Even in the answering affidavit filed by our learned friend yesterday, there is not a single fact that shows why, in the interest of justice, Mr. Cekeshe should remain in prison. Not one fact. It really makes one wonder, why is the state hell-bent on keeping him in prison? If they have no basis that they can confidently put under oath. The best argument they have come with is that let's wait for the petition to be decided. But if they're wrong in law then, that an application can be brought as soon as leave to appeal has been sought. Your Lordship knows in much more serious cases where people are asking for bail, waiting for their appeal. And there can be no harm to the state here at all, quite apart from the fact that they don't produce any harm. There can be no harm to the interest of justice at all. Mr. Cekeshe has been in prison for 22 months since his conviction. 22 months. No reports are given about misconduct or anything. If there was any report about the way he has conducted himself, no doubt the state would have ferreted it out and it would have produced it, because they are so hell-bent in opposing this application. But zero evidence whatsoever. So you have an odd situation where the opposition to bail is the most technical. Once we go to substantive questions, the state simply collapses, produces zero evidence, but they nevertheless say it should be opposed. So, on interest of justice proper, if we look at the sequence of the fact that we are dealing with an accused person who was out on bail, even post-conviction, and Your Worship made two vital points. that one, I don't want to increase the amount, and two, I don't believe he's a flight risk. What is the reason then not to give him the benefit of his release? Of course, if we accept the facts that we know today, that we are not dealing with someone who has a troublesome, problematic character, there is no reason to believe that if he fails, then he will not be rearrested and then serve out the rest of his sentence. So the only risk that the state could possibly produce is the risk that there is a likelihood that he will not be able to serve out the rest of his sentence should he fail. But it is striking, Your Worship, that they are not even confident to put that argument on paper. They cannot even say to Your Worship that we fear that if you release him, we have a risk that if he loses, he won't come back and serve the rest of his sentence. When that is measured against the really strong possibility that that conviction may be overturned, or at the very least it is argued, then it becomes grossly injudicious to keep him in prison in circumstances where he has an arguable case on appeal that would overturn the conviction. Because it means the 22 months that he has spent would have gone to waste. It also means any further period of incarceration then becomes incarceration for its own sake. It becomes punitive. But no one should use the law for punitive reasons. One should use the law for justice. So I would submit to Your Lordship with the greatest of respect that in the absence of any evidence in the interest of justice that my client should remain incarcerated beyond this application for leave to appeal, Your Lordship should exercise Your Lordship's discretion and release the accused. There is not even a debate with our learned friends about bail amounts. There is nothing at all, complete silence on questions of interest of justice. So it still remains within Your Lordship's Your Worship's discretion to release the accused on bail. And if I am right in one aspect of my argument, which is that the failure to question could conceivably be a ground to quash the entire conviction, then there is really no reason why the accused should continue languishing in prison. We have set out in full the typical bail requirements in the actual application before Your Lordship. The section 60 considerations. So these are contained at paragraph 58. One, no evidence that he will be a risk to the public. No evidence that he will evade the finalization of his appeal. No evidence that he may interfere with any state witnesses, of course, because this is an appeal. No evidence that he will jeopardize the functioning of the criminal justice system. No exceptional circumstances that would lead to the undermining of public order or peace. He doesn't own any assets, doesn't have any financial means, doesn't even have a passport. No basis to suggest that he will not keep to any bail conditions that may be imposed. And we have an answering affidavit. It's completely silent on paragraph 58. This must therefore be accepted as established. We've got a final point on the issue of legal representation. The Lordship would have noted in my address that I have spent a considerable amount of time trying to illustrate the flaws in the way in which the 112 process was undertaken. Now, these flaws should not be taken as criticism of the court. The source of this appears to be what we have described as incompetent legal representation. Your Lordship knows that in certain cases, such as S versus Baloi, S versus Mashini, S versus Tando, incompetent lawyering can wreck a trial. And if incompetent lawyering ultimately results in incorrect concessions, incorrect pleas of guilt, it may undermine an accused's right to a fair trial. If it does so, it may result in a failure of justice. That is the legal position as confirmed by Justice Cameron in S versus Tandwa, which we cite at paragraph 33 of the application. But again, this is not an opportunistic point. It is easy for counsel assuming the case to believe that they will handle it more competently than the previous counsel. But this is an extreme case. It is an extreme example of incompetent lawyering. We've set out in full at paragraph 37 18 instances of incompetent lawyering, the cumulative effect of which is that Mr. Cekeshe simply never had the right to legal representation that is provided for in the Constitution. 1, constant interruptions. Your Lordship remembers you ran the trial. I felt for you when going through the transcript. Incoherent rambles. I've cited only one when your Lordship asked a simple question: is this not a duplication? When argument was made about postponements, counsel wanted to call witnesses to argue a bail application, simply illustrating that he was not familiar with the procedure. He was constantly late for court. There is an instance where your Lordship says to the accused, "Where is your lawyer?" Somebody else shows up, and then they say, "I don't have instructions." Finally, counsel arrives at 12:30, and the Lordship is very cross about that. But the fact that counsel is constantly late for court is prejudicial to the accused because it affects the climate and the atmosphere of the trial. At some point, counsel says he's an attorney, and the next moment he says he's an advocate. He constantly asks for the matter to stand down because he's not prepared and he doesn't have his house in order. He then gives the advice to plead guilty, but he never explains to the accused that the state bears a duty to prove its case beyond a reasonable doubt. And he doesn't explain that the accused has no duty to prove his innocence. Number 8, he advises the accused to plead guilty, does not bother to canvass a plea and sentence arrangement with the state. And if I can put a pause here, the Lordship, it's so clear what happened in this trial because as soon as the conviction was entered, counsel for the accused was utterly astonished. He came up, initially applied for leave to appeal against the conviction, which he has just admitted. And then thereafter shifted to apply for leave to appeal in relation to sentence. What is clear is that he never imagined that he would get 8 years. But that's his fault because he never canvassed the issue with the prosecutors. And what is clear is that there was just never advice given to the accused that if you sign the statement, you can be sentenced to 8 years. And then he also did not know the rules of evidence. I made one example. At the end of the reading of the 112 statement, they hand up photos without any attempts at authenticating. It was left to your Lordship to remind them what the rules of evidence were, when your Lordship refused to admit photographs handed up in court without any attempt at authenticating them. He objected to hearsay evidence, and your Lordship had to say, these are sentencing proceedings. This evidence is admissible. Very little is to be said about the cross-examination because it is plain that it was dismal. He admitted during the course of the trial that he is what is called a civil law advocate, and criminal law only comprises 20% of his practice. And he accepted that he does not know or understand the criminal law process. What is he doing in the criminal court then? Then on sentencing, the Lordship remembers, the only evidence that is left is the probation officer's report. But the accused is here, never called to explain the context. In his statement, he says, I joined it because there was a protest, I joined it in solidarity. Never called to explain any of those for purpose of sentencing. And 14, I've already explained this to your Lordship, that the consequences of an immediate guilty plea in relation to sentence just never explained to the accused. Then there is the confusion around the application for leave to appeal. The affidavit of Mr. Stay, the Lordship has read it, shows that I was briefed in December 2018. But the leave to appeal had already been dismissed by February 2018. And they seem to have just absconded since then, without any attempt at taking the matter up to the High Court, or any attempt at coming back to your Lordship to ask for bail, or anything of the sort.
You seem to be under the impression that outright sight involving recent documents that have been of your 30. I never had sight of anything.
Oh, is that so?
It was not handed to me.
Yes.
This matter was enrolled for today without my knowledge. I was not asked whether this date would suit me. As a matter of fact, I was not even available. To my surprise this morning, when I came to court, I found that this matter has been enrolled. And to my further surprise, the matter is being argued without any heads of argument, any affidavit, no replying affidavit, nothing being handed to me.
Yes, that is unfortunate, my Lord. Can I explain?
Indeed, it is unfortunate.
Can I explain that what happened in this case is that last week we were before the High Court on an application for bail pending the outcome of the petition. I argued the case in the morning of Tuesday. The judge then stood us down to say that he will hear us in the afternoon, but he wants us to discuss with the prosecutor. Between 11 and 1, I discussed with Mr. Motibe, I think, and 2 of his seniors. The agreement, which was subsequently introduced into court, was that the following day, Mr. Motibe and my attorney would come here to make an arrangement for the hearing of the case. They, in fact, came that very same day on the Tuesday afternoon. I think Mr. Motibe didn't come, somebody else came. And they made arrangements. My understanding was that those arrangements were made with the right people. That the matter would then be heard yesterday, the 8th. I subsequently got told that the 8th was no longer suitable, it would be heard on the 9th. But insofar as the bundles of documents are concerned, I've been assured, in fact, I've seen them with the stamp. I've been assured by my attorney that they were handed in. So I wonder whether there is a problem with the administration that resulted in the fact that the documents didn't make their way to your Lordship's attention. The heads of argument were filed on time. The answering affidavit of the state, again, this is another issue that needs to be mentioned, especially given that these are public hearings. The state told us and agreed before the High Court that it does not know if it will oppose bail. If it decides to oppose bail, we will be notified before the end of the 7th of October. The 7th came and went, we had nothing. On the 8th, at about 4 p.m., we get the 8-page affidavit from the state telling us that we are opposing. No request for condonation, no explanation why this was not done on time, no explanation why we were not notified on time. But because we are acting for an accused who is sitting in incarceration, and because it's in the interest of justice, that we decided we will not complain about the conduct of the state in the way that it has treated us. May it treat us badly, but the impact is on our client. And we decided we will absorb whatever the state is throwing at us in order to make sure that the case is run smoothly and there are no unnecessary delays in the matter. But I can give your Lordships my own commiseration that the papers have not been given to your Lordship, because that is just unacceptable. Because the papers were delivered on time. All of the documents I've been relying upon today. they were delivered on time. I'm happy for Your Lordship to stand us down to read through the most important documents are our petition, our application for bail, our heads of argument, the answering affidavit by the state. If Your Lordship has those four, Your Lordship will follow every point I have made. The cases that I've been relying upon, we've made copies so that they can be handed up in court. So I have been relying liberally on these documents on the mistaken belief that Your Lordship has them. But I apologize that it turns out that Your Lordship doesn't.
I made it clear this morning in chambers that I haven't had sight of any document whatsoever and that I was not known in enrolling this matter for today. But I've allowed you and the state to proceed with the application. Can I just in passing refer you to paragraph 72 of the heads of argument, now that I found it here amongst the bundle of documents that's been placed on the bench this morning.
Yes.
Paragraph number 72, page 24.
Yes.
It says that no record exists of the court's judgment when sentence was handed down.
Yes.
Now, how come there is no record? Because this court gave full reasons and gave a well-considered judgment when sentence was handed down. And I do have a copy of that.
Yes.
How come you don't have a copy?
Yes. And the problem is not even this one. Even on the, we set this out, that even on the days where the transcription is available, there are big chunks that are just missing, where you can see the argument makes no sense because something should have been said, but it's just missing.
Well, I was never approached for a reconstruction.
Yes.
Now I read here in one paragraph that you don't even have had sight of my reasons for sentence.
My learned friend and I actually discussed this morning. He says that some of the submissions that he was making have either been scratched out or have not been transcribed. And then it looks like the submission is incoherent, but he says there are portions that are just missing. So there is a big problem with the record in this case. There is a problem with those days that are available that are just not properly transcribed. In fact, if Your Lordship has regards to Mr. Staines' affidavit,
which I haven't had sight of.
the application for bail. Yeah, Your Lordship.
But I don't want to stop you in your application. Carry on.
Yeah.
Carry on. At the end of the day, I will adjourn the matter and consider your application. In the meantime, my court role is being affected because I was not known beforehand when this matter was enrolled. And I've got matters set down for today for trial. I've got other matters set down. And all those people are waiting in anticipation. If I was known beforehand, I could have given you and State Council a date that would have suited me. But it is too late now. So carry on with your verbal arguments, and I'll allow State Council to respond to that, and then I'll reserve judgment in the matter.
So if my learned friend wants to say something to me.
Probably that you've got 10 minutes left before lunch.
If your Lordship looks at paragraphs 7, 8, 9, and then it goes on. So what Mr. Staines says. I should use mine. Yes. So Your Lordship asked, directing Your Lordship's attention to paragraph 7, 8, 9, 10. This is what he says. Despite a thorough investigation and numerous searches, I have been unable to locate a copy of the judgment, and I have been unable to obtain the recording and/or transcripts of the sentencing proceedings of 4 December 2017. I'm only in possession of the transcripts of the proceedings on 28 October, 2 February, it goes on. But what the point I was making about those particular transcriptions that are available contain large gaps. And then, from paragraph 11, he explains when he was appointed. And then he says, due to the absence of transcripts, I contacted digital audio recording transcriptions for the missing transcripts. I exchanged the following correspondence with digital audio to obtain the transcripts of the applicant's trial, his sentencing, and the first application for leave to appeal. Then it sets out everything that's happened there from essentially December 2018 right up to April 2019 of the attempts that he has made towards getting a sense of what this trial was about. And then it seems that nothing was forthcoming. And so we've had to cobble together those portions that we could find and then try and make sense of what actually transpired at the trial.
So are you saying that you still not in possession of a copy of this court's judgment?
No, we still are not. Not on sentencing. In fact, we've said this to the...
I've seen this court judgment or the verdict.
Yes.
Which one?
No, the judgment is... There's no separate judgment. We've got the judgment that's handed down orally. That part is transcribed. So it's included in this sense. But that's only the oral delivery of the judgment. But the sentencing proceedings of the entire 4th of December 2017, we simply do not have. And those portions that we have, there are gaps in those portions about things that were not transcribed and things that have just been scratched out. So it seems to us that there will still be a big job to be undertaken for later purposes, not today's purposes, for later purposes on the reconstruction for the Court of Appeal. But my learned friend who was part of the trial, this can help us to reconstruct. Now, I had mentioned 14 items. There is more, 4 more. The failure to apply for leave to appeal, I've already dealt with that. The confusion around the leave to appeal. And the fact that they applied the civil DS non for the criminal trial. And the fact that they confirmed their ignorance of criminal law. And then we've mentioned the 18th part, which is this confusion around.
Advocate Tembeka Ncukaitobi making representations there for fees must fall chap Kanya Cekeshe, who's been in custody for 22 months, basically looking to get that overturned. We're going to go for a break, of course, and at the top of the hour we'll have more on-point news for you. Do stay tuned.